Papakilala ko po sa inyo ang ating energetic, masipag at top performer, part of our management team ni Secretary Castriciones. So siya po ang ating OIC Assistant Secretary ng Legal Affairs Office and concurrent board member. At siya rin po ay isang awarded ng plaque of recognition for the zero backlog, zero balance caseloads for 2017 and most cases resolved for 2018. Okay, and designated by the Secretary as the Chair, Primary Bids and Awards Committee since June 2019 and Chair of the Land Use Cases Committee since 2019 and Committee of PRFC. Radar representative to the EVOS Act. So, palakpakan natin and we welcome our resource person, Asec Jim Coleto. Good morning, sir.
Maayong buntag sa tanan. It's really a wonderful opportunity despite this COVID-19 pandemic that we have. We're still on schedule with this training. And hopefully you will have a meaningful and successful training, and you will get to apply this as you go back to your respective tasks, functions. And as you know, much is expected from us. And sabi nga ni Spider-Man ba? As a spider, with great power comes great responsibility also. So anyways, with that, I'd like to start the lecture assigned to me. This is Administrative Order Number 1, Series of 2002, otherwise known as the Comprehensive Rules on Land Use Conversion. This was amended during the time of Sec. John. This under the Duterte administration via AO1 Series of 2019 on streamlining. And you must have heard some questions during the House of Representatives plenary hearing concentrated on this AO1 Series of 2019 as well as AO6 Series of 2019 regarding the creation of the LUCC. Now, as legal basis for this AO1 2002, because this is sort of the Bible, pardon the use of the term, for land use conversion, serves as the Bible, our Bible, as regards those assigned in Regional Land Use Committee and those at the LUCC level. You have to familiarize with AO1 Series of 2002. Yes, this is an 18-year-old plus administrative order, yet this is very comprehensive enough, encompassing all the prior laws issued. So this AO is actually repeals the prior AOs on conversion during the time of Secretary Garilao, during the time of Secretary Morales. So the basis for this issuance is, one, we have Section 49 of 6657, which is actually the quasi-legislative authority vested with the DAR or through the DAR Secretary to promulgate rules and regulations for the purpose of carrying out the objects of the comprehensive agrarian reform. And in this case, you have Section 50 also under 6657, which vests in the Department of Agrarian Reform the authority to adjudicate, resolve agrarian disputes. And this is with regard to the darable matters or those cases cognizable by the PARAD or the RARAD and on appeal by the Darab Central Office, of which this representation is one of the board members, regular board members. Now, as regards controversies, issues, matters relating to the implementation of agrarian reform, which is also vested with the Secretary of the DAR. You have these cases known as the ALI, the Agrarian Law Implementation. And again, this is an example of this is the land use conversion and exemption, which I'll be tackling today for you all. So that's the legal basis for this AO. And in addition, you have sections 4 and 5 of EO, Executive Order 129-A. I repeat, 129-A. Then promulgated during the time of President Corazon Aquino, when she was then exercising her revolutionary powers. So it had the effect of a legislation. So that's why until today it's still in effect because it was considered a legislation, a legislative act. And that is the authority why, regardless of the hectareage, under 129-A, we have jurisdiction on land use conversion. Because you might be asked, under Section 65, also, which is the source of the authority for land use conversion as well, since it says that when the land ceases to be economically feasible and sound for agricultural purposes, and or that the land will have greater economic value, or the land is urbanizing, then after 5 years from the award, the ARB or the landowner of a retained area, take note, retained area, 5 hectares and below, will be able to apply for land use conversion. Now, where does it say that it is beyond 5 hectares? So baka may magtanong, Section 65 merely says 5 hectares and below retained area, and at the same time for the ARB, which is 3 hectares and below. Yet, we have authority to accept even beyond 5 hectares. So that's why you have central office accepting applications for more than 5 hectares land holding. And the authority is Section 4 and Section 5 of 129-A. And in addition to that, under the Administrative Code of 1987, again, the authority to approve or disapprove land use conversion is vested with the Department of Agrarian Reform. So those are the legal basis why DAR takes cognizance exclusively, please note about it, about land use conversion. Okay, we proceed with the statement of policies because from the legal basis, very clear on this statement of policies why we have land use conversion. First, because we have to preserve prime agricultural lands to ensure food security. Di ba, as population increases, which is more than 109 million Filipinos now and counting, definitely there's a need for housing purposes, residential, and those for commercial, etc. So we have to, not that we're against conversion, but we have to preserve these prime agricultural lands against the indiscriminate use of lands, because we need food. We need, that's for sustenance. And I guess I do not have to belabor this point that this is really a must. Of course, you must have heard comments coming from Senator Cynthia Villar, but that notwithstanding, we really have to preserve prime agricultural lands for food security purposes. And this is very clear in the AO, and as you must have read and you will discover for those new ones in the DAR, this is very strictly regulated under 6657. That's why there are penalties for premature conversion or for unauthorized conversion or for illegal conversion, which are all stated under Republic Act 6657 and those under Republic Act 8435 or the AFMA law, the Agricultural, Fisheries and Modernization Act, which defines premature conversion as the alteration or the use of the land without a prior DAR clearance. Also under Republic Act 9700, very strict because even if already granted, meaning approved conversion order, with approved conversion order, if you cannot develop within 5 years and there's no extension of that within the 6 months prior to the 5-year lapse, again, it's the law says it shall be automatically revoked because it should be covered under the Comprehensive Agrarian Reform Law. Now, there's also under 9700 very clear prohibitory mandate that in case of irrigated and irrigable lands, the same are non-negotiable or non-eligible for land use conversion. And later on, you will learn that the intent, legislative intent of 9700, amending Section 65 of 6657, is to ban conversion also as or exemption of irrigated or irrigable lands. That's why you have DOJ Opinion 43, series of 2011. And the second policy statement is as regards to all sectors of the economy and all regions be given optimum opportunity. Why? Because under Republic Act 7160, remember the local government code, it vests in the LGUs the authority to reclassify lands, right? So every year, or there's a provision there that they the highly urbanized, the independent component city, or the chartered city, or component city, and municipalities, they have all the right to reclassify lands, agri-lands at that, into residential, commercial, industrial. And because of this, because the local government code, section 20, last paragraph of that, also provides that although they can reclassify, but the same is subject to conversion rules of the Department of Agrarian Reform pursuant to Section 65. So that's why I will attempt to put a distinction between the two, reclassification versus conversion, and as interpreted by the Supreme Court. And there are jurisprudence I will cite later on, especially which I place in the lecture on exemption. Okay, so that done, statement of policies, we now proceed with the meat of this lecture. Okay, next please. So what's within the coverage of these land use conversion rules? First, you convert into residential, commercial, industrial, institutional, and other non-agri purposes. So that's clear enough. From conversion means the act of changing the actual use of the land into non-agricultural purpose, which is either residential, commercial, industrial, or or institutional like schools, etc. But when it comes to churches, I'd like to emphasize church places of worship. Please recall AO5 series of 2007, which vests in the Provincial Agrarian Reform Officer, ARPO 2, the authority to approve, so long as the area does not exceed a certain, I think, 1,000 square meters, and they have to submit the plan even the churchyard should not exceed more than 1,000 square meters. And that's the PARPO that approved. So that was an amendment introduced during the time of President Arroyo when the secretary was Secretary Pangandaman and I was, well, the head executive assistant. Okay. Second, development into other agricultural activities such as livestock, poultry, fish pond, which will exempt land from cap coverage. Please note, in this case, livestock, poultry, and fish, livestock, poultry, you have the loose farms case, which says that these lands are supposed to be industrial, so exempted. So that's why very clear ang statement dito which will exempt land from cap coverage. So if that is the attempt, then it's more than 5 hectares, for instance, so it falls under the LUCC, and therefore the landowner will have to apply before the land can be used as livestock, especially if the land was reclassified only after June 15, 1988 by the LGU. So, and then you have fish ponds under Republic Act 7881, which was passed in 1995, which classifies fish ponds as non-agricultural. So therefore, if your land is a fish pond, if your land is agricultural and you want to convert it into fish pond, then you have to apply for conversion, especially after March 1995. Okay, and then conversion into non-agri use other than that previously authorized. Please note that this is the this presupposes, number 3 presupposes that the land is already converted into residential or commercial, but you want it to be, say, this is residential and you want it to be transposed or transferred into, you want it to be commercial or industrial or mixed use, you need to apply again. Otherwise, you can be administratively charged for unauthorized conversion. The example is the Sumilaw case in Bukidnon. That's the famous Sumilaw, which became the focal point of during the time of Sec Pangandaman, because it was approved for industrial and yet no, it was approved for residential, and then yung actual ginawa nila without an application, diniretso ginawang pigiri. It became a sort of a controversy, and that's why it resulted to this resolution na yes, covered, and then the landowner will have to file an application. Hindi pwede yung legal opinion. And then number 4 has to do with the conversion of agri-lands because of reclassification made by the LGUs. Here, I'd like to emphasize that under Republic Act 7160, Local Government Code, sabi ni Secretary Drilon in DOJ Opinion 44, that the authority to approve land use conversion is prospective, meaning it starts on June 15, 1988, because that's the time that the Agrarian Law or 6657 was passed. So if the reclassification made by the LGU happened before June 15, 1988, then what applies is exemption clearance. So you have AO for 2003. So that Drilon opinion was the subject of the famous landmark case of Natalia Realty versus Dar. So it's a must read for everyone. So that serves as basis why you have conversion and then you have exemption. And then if there's also a presidential proclamation made, for instance, by the president declaring a certain area in Mindanao, in Davao, or Bukidnon, or in Surigao, in Butuan, as an export processing zone authority, Well, it's not automatic that it is exempted or that exempt from applying for land use conversion, because under this rule and under the uh, uh, under Republic Act 6657, there's a need to apply for the locators within that zone to apply for land use conversion. Okay. So if there are areas to be converted, what about areas that are no or not eligible or non-negotiable, as the word says in the land use conversion rules for conversion? First, okay, you have the NIPAS, the network, the National Integrated Protected Area System. These are important for climate change, environment. This is environmental protection actually, and geologically, these lands are supposed to be protected and therefore non-negotiable. So what are those falling under the NIPAS? Yung mga mossy and virgin forest, definitely, kasi source of water. River banks also, kasi alam mo naman, pag i-ano mo yun, i-convert, the more na damage sa ano natin, kasi di ba it will find its way kung anong natural course doon talaga dadaan. So kung harangin mo yun, definitely yun yung issue nga dyan sa yun sa remember yung Rojas Boulevard. But anyway, that's not agricultural, but that will happen. And then second, all irrigated lands. Actually, yung sa AO1 2002, nag-include pa ng distinction. Irrigable lands also, pero sabi ng law, automatically repealed yung proviso ng AO1 2002 because under 9700, amending Section 65, all irrigated and irrigable lands are non-negotiable. So sa irrigated dati, may distinction na pag may irrigation facilities or with firm funding commitments or without firm funding commitment, my chance highly restricted. But then, especially for irrigable. Pero under this under Section 65 as amended now by 9700, all irrigated and irrigable with firm or without firm funding commitment are non-negotiable. So if there are no for land use conversion, there are also so-called highly restricted areas for land use conversion. Bakit highly restricted? Please note, one, if that is a land already issued with a notice of land valuation or with a perfected agreement for voluntary land transfer direct payment scheme. Naantala lang, covered with notice of coverage, tapos na-proceed pero na-pending kasi may mga protest, blah, blah, blah. Tapos naabutan, meron ng land valuation from land bank, my perfected agreement with the landowner under under VLT DPS, voluntary land transfer, kasi mag-direct payment na lang yung farmer identified beneficiary to the landowner, pero hindi pa na CLOA, okay, na-register. Why? Kasi may mga issues probably sa mga meets and bounds. So anyway, pag gano'n na ang sitwasyon, pwede pa rin siyang applyan, pero higher ang ano sa kanya because we have to look strictly on the documents, whether pwede ba talaga ma-convert, yung feasibility study, yung socio-economic benefits niya, nag-outweigh ba sa kung ituloy yung pag-distribute ng CLOA or CLOA, yes. So in this regard, highly restricted siya kasi stringent yung not that sa iba hindi stringent, yes, stringent just the same, pero we have to look into it na whether mas better ba i-cover siya or i-convert na lang. and then lands within the environmentally critical area. So pag sabihin ng DNR na it is within that environmentally critical area, then there's a need to submit an environmental compliance certificate. Kung nagsubaybay kayo yung plenary hearing, yung isang congresswoman from Gabriela, si Congresswoman Brosas, was asking about mga ECC, kung may submission ba. Please note that under AO1 2019, sabi ng DNR, yung ECC is a post-compliance. So what we do, kung may certain land na may certification na it's within the ECC, yes, highly restricted, pero pwede siyang ma-convert. But after the grant, we place in the dispositive portion the submission within a certain number of days of the ECC before mag-start siya mag-project, assuming walang protest and it becomes final and executory. So that's the situation. Okay. And then also agro-industrial croplands kasi devoted to existing agricultural infrastructure or agro-based enterprise, industrial and agricultural, and then applyan mo for land use conversion. So therefore, we have to look into the viability of the application process. Baka naman, it's just an attempt to circumvent the coverage of the program kasi nga more than 5 and at the same time, ayaw wala naman palang intent talaga na i-develop yung lupa into non-agri. Meaning, kasi nahuhuli mo, wala naman palang capital, yung developer or fly-by-night. So anyway, those are considerations. And then last one, highland or areas located in elevations of 500 meters. Yung nandun sa CAR, especially sa Benguet, or other parts there sa Kalinga, Apayao. So merong the land is supposed to be devoted for highland or high value crops. We have a law on that na ini-encourage nga yung mga doon na situation na above 500 meters. So highly restricted din siya kasi nga because mas better siya for food security purposes, etc. Kasi known naman talaga yung mga lupa doon na maganda for high-valued crops. Okay. And then, in addition to highly restricted, there are also areas known as priority development areas and projects. Dito nag-come in yung government, although the government, not necessarily the government is the one applying. Here, you have endorsements made by the government kasi nga yung areas are suited for industrial, commercial, blah, blah, blah. So you have DTI and the DA endorsing the same. So we have to prioritize these conversion projects kasi nga for the economy and then for the purpose of industrialization din ng Pilipinas. Then you have tourism development areas kasi suited siya for tourism purposes. Okay, so that's a priority, meaning yung actually because of AO1 2019 at par na rin halos yung priority sa kanya because it's endorsed by the government. But same OSII within a certain number of days, then priority for deliberation, and then resolution agad. And then for ecozone, those are also priority areas. And then even government-owned lands. But note, these government-owned lands are supposed to be patrimonial property or those acquired by the government under its proprietary function, as distinguished to those na hindi pwedeng like for public purposes, because you have Section 6 of 6657 as amended by 9700 na hindi na mag-apply for conversion and hindi rin pa-applyin for hindi mag-apply yung retention, right? ang ano lang consideration diyan is kung LGUs ang nag-bought or in any other capacity, not just expropriation, other modes of acquiring ownership, hindi siya covered sa retention na 5 hectares and below. And then kung convert, hindi na magdaan sa DAR. Okay? So please take note of Section 6 of 6657 as amended by 9700. Okay? Kasi may kolatilya doon na kung na-covered na, may ARB na, then the ARBs have to be paid disturbance compensation. Those sites for processing plants of agricultural products are also priority development areas to be determined by the DA kasi hindi naman ang DAR ang nag-ano dyan. Okay. And then those telecom facilities endorsed by the NTC, National Transportation Telecommunications Commission, and the housing projects as well. Very may law citing na pag mixed use or that it's for social purposes. So therefore, priority. In fact, mayroong one-stop shop created for that purpose. Okay, and energy projects are also included in priority development areas. Now, what's the criteria for conversion? So please note, so in considering whether the land applied for land use will be granted or not, ito yung bantayan nyo. Una, whether the land is not among those non-negotiable. Kung nipas ba siya, irrigated, irrigable ba siya. So, it's a no-no. Okay, second. Second, yung nasa 65, yung when the land cease to be economically feasible and sound for agricultural purposes as determined by the DA. Okay? And then when locality has become urbanized or that the land will have greater economic value for residential, commercial, and industrial purposes as stated as reclassified by the local government unit. So kaya need yung mga certifications galing from LGUs, whether an HLURB for highly industrialized cities, kasi nga sila yung vested with authority to reclassify lands into such purpose. So what about kung the land is already is being applied by the ARB? Pwede ba? Yes. After 5 years from the award, not 10 years. 10 years is Section 27, yung voluntary transaction. After 10 years from the award, pwedeng ibenta to either by to another qualified beneficiary or to the DAR land bank or by hereditary succession. Yun yung doon. And you have AO8 series of 1995 as amended by AO1 series of 2017 na kailangan 10 years plus 10 years plus fully paid sa land bank if ever covered under VOS or by compulsory acquisition. Now, as regards conversion, si ARB, yes, provided after 5 years but not necessarily 10 years. Next, na pwede niyang bayaran even if hindi pa siya fully paid, pero kung mag-apply siya and then granted yung application, bayaran niya he must pay fully the amortization in land bank, and then at least 10% of the proceeds will be invested in government securities. Ito yung mga dalawang condition na na-amend yung Section 65 ng 9700. Dinagdag ito na pwede siyang mag-apply provided na pag mag-granted, tsaka bayaran niya fully. Dati kasi, the rule is pwedeng mag-apply only kung fully paid. That's why you need land bank certification. And then, yun. He must fully pay the price after na under 9700. Okay. So where to secure application forms? Madali na lang to. You have BALA LUCD, LUCC Secretariat pursuant to AO6 series of 2019, creating the Land Use Cases Committee. So pag 5 hectares and above, doon sa BALA LUCD, LUCC, and for 5 hectares and below, RLOC or the regional office. Okay? Or you can download the application forms naman in our website. Okay. Where to file? Kailangan alam nyo naman. So help us out, disseminate the information. Okay? Whether you're with the RLOC or in the province, we need your help in disseminating the information. LUCC, okay, above 5, and RLOC, 5 hectares and below. Okay. As to payment, ito pa rin under AO1 2002, masyado nang behind, pero that's the but subject to amendment din ito. The filing fee is 1,000 for those below 5 and to be filed before the RLOC, but the inspection fee is 10,000 or depending kung the same region ba siya, like 4B, tapos yung mga provinces, island, so magiging 15,000, 1,000 plus 15,000. Okay. Or sa Mindanao, in Surigao, may Siargao. So malaking kung Siargao ang or although below 5 pero 15,000 kasi it's not the same. Okay. Okay, pag above is 2,000 and then 10,000 the same Luzon area, or outside Luzon but in Bicol, that's 15, okay? And then for Mindanao, kung dito sa Central above 5, it's 22 plus 20, okay? Approving authority, because of AO6 series of 2019, pag above 5, again, LUCC and those adjacent or previously granted, kung katabi, adjacent. So dito na sa central. Okay? Single project with different owners, again, central siya. Okay. Okay, for 5 hectares and below, again, regional director. Delegated authority to the regional director. Okay. Ano yung mga grounds for revocation of conversion order? Ito yung karamihan siguro may mag-approach sa inyo, mag-consult, and so this is potential for use in your mediation also. Ano yung mga grounds like lack of jurisdiction, like kung hindi naman pala 5 hectares, say chop-chop, famous kasi ngayon na may mga so-called chop-chop, intentional na para mag-fall lang sa region. I'm not particularly attacking, pero meron kasing unscrupulous applicants, I'm not generalizing, na kasi nahuhuli namin pina-revoke dito sa Central. Anyway, na ganun ang ginagawa. So it's LUCC can revoke that kasi nga supposed to be LUCC yung jurisdiction, hindi sa regional director. Or that there's misrepresentation of facts kasi irrigated pala or irrigable, tinago. So pwedeng i-revoke yun. Or non-compliance with the conditions, like kasi sa dispositive portion, merong nakasaad doon na say you have to put up a bond, performance bond, etc. I-convert yung guarantee against premature and then pero winidraw pala, hindi so those are valid grounds for revocation. Okay? And then non-compliance with agreement or payment of disturbance compensation. Please note, I'd like to emphasize here, dalawa kasi minsan ang ginagawa prior to applying for land use conversion, nagkaroon na ng agreement. So that's when the situation calls for you to mediate kung amenable ba siya. Usually hindi naman sinasabi. Binibili na lang yung lupa and then babayaran yung landowner. Later on, meron na palang land use conversion. So in that case, hindi pa disturbance ang ibibigay sa'yo. What applies yung Section 30, provision in Republic Act 3844, yung whether yung voluntary surrender is advantageous ba sa kanya. So how do you compute that? So titingnan mo naman kung kasi yung Section 36 on 3844 applies only if there's conversion a conversion order, or that yes, conversion order, so 5 times 5 the average gross harvest of the last 5 preceding calendar years. Now, assuming may agreement, nag-affidavit of undertaking yung landowner, naging forthright siya na I will apply for land use conversion later on. So, pero mag-agreement muna tayo, I will pay you afterwards. So, yun, nag-apply, na-approve, tapos hindi naman pala siya nag-comply later on. So within the number of days, 90 days from discovery or from the occurrence, from the time ng approval, but within 1 year, pwede siya mag-file kaagad ng revocation for non-compliance with the undertaking to pay disturbance compensation. Kasi under the rules ng land use conversion, even a share tenant or lessee is entitled to disturbance compensation. However, you have to distinguish na pag share tenant siya, automatic yung Section 36 kung mag-apply, kasi merong jurisprudence by the Supreme Court na only share tenants or lessees with agricultural leasehold contract are entitled to disturbance compensation. But under the rules on conversion, even actual tillers within the area, even without security of tenure, are entitled to conversion, but to disturbance compensation, but not necessarily yung Section 36 ang mag-apply. Okay? So conversion for purpose other than land use conversion, yun yung may violation, so pwedeng i-revoke, and other serious violation. Why? Kasi again, sa last paragraph ng Section 65 now, as it stands, pursuant to an amendment by 9700, pag ang with approved land use conversion fails to develop within 5 years, or due to the fault or violation made by the applicant, landowner, or ARB, the same shall be revoked and covered under the Comprehensive Agrarian Reform Program. Yun yung amendment sa 9700. So these are documentary requirements, but note yung AO1 series of 2019 amending AO1 2002, kasi nga may mga pagbabago, 18 years na yung isa, so expect yung streamlining process na gusto ni President Duterte when he assumed office, na dapat mag-follow ng ease of doing business, at the same time dapat reasonable, rational yung process na ina-adapt ng kada opisina. So when the streamlining process was made, crafted, it was crafted in such a way as to strictly adhere to what the President wants us to do when it comes to conversion orders, exemption, and even ali cases in general. Dapat bilisan. So, but what applies, because there is a DOJ opinion made by the Secretary Guevara, na when it comes to conversion, ali, these are within the exercise of the quasi-judicial power. Yes, siya, darab at saka quasi-judicial, pero govern tayo ng Section 51 of 6657, which says na within 30 days from submission, dapat i-resolve. Of course, merong an exception doon. Okay. So proof of payment of necessary fees. You have notarized application. Personal filing is required of the applicant, or kung may, dapat with SPA. Okay, and then electronic copies are also the mandatory. for OCT or TCT kasi nga ang mga RODs are now into filares or the so-called electronic copies. Okay. And then true copy of current tax declaration, kailangan yun kasi sa assessment ng bond or to guarantee against premature conversion, and then later on for performance bond. Okay? So doon ba makikita kung pursuant to the DOF zonal valuation. Okay. Course, project feasibility study, yung mga GVA, usually kasi si farmer, hindi naman niya kaya kung mga residential yung purpose. So naki-enter siya into a joint venture agreement. We have to look into it. Okay? Na in such a way na siya pa ang owner, hindi na bininta. Although in some, parang manotice mo na talagang ano na lang, nakakulatilya na upon approval, bayaran din siya. So, yes, you have to check on the business arrangement. Okay. Well, the narrative description of the development plan is also a must because you have to check kung kaya ba within 5 years. Kasi as a rule, 5 years yung approval. So at least makikita mo anong plan A, and then for year 1, then year 2, ano yung, kasi kailangan mo malaman din yung schedule nila kung totoo bang may project na ganun. And then proof of financial and organizational capability. So dito makikita kung yung developer is fly-by-night or hindi pala capable of handling the project. So it's an attempt to circumvent. The socio-economic benefit cost study, kailangan na, that's why we have in the committee expert dito because kailangan mo kung ano yung benefit cost study, kung mas maganda i-cover or that it remains as such agricultural or go with the conversion purpose. So titingnan mo doon kung talaga bang yung project is beneficial. That's why kung may protest, there has got to be public consultation. Kaya meron tayong AO5 2018, go through consultation process, especially kung may environmental effect or damage to be caused to the community. So you need to check on that. Photos, kailangan yon kasi i-determine, saan ba to, totoo bang yung sa lupa. Okay. And then the SPA or board resolution, kung corporation yung nag-apply, and then concurrence kung naka-mortgage pala with the bank. So dapat with concurrence letter from the bank. Okay. Ito yung importante din na mag-come in yung expert as mediator or because magiging MARPO din kayo later on kasi nandyan na kayo, pataas na. So ano yung dapat i-issue ni MARPO? Yung status of CARP coverage, kung na-issue ng notice of coverage, kailan, ano yung nature, VOS ba, CA ba, or government-owned land ba yan? Okay. Condition sa posting kasi ipuput up doon yung billboard. Okay. And then presence of farmers. Kaya ikaw magtingin kung meron bang leasee, farmer, actual tiller within the area being applied for land use conversion. Kaya very must role yun sa MARPO. And then posting of notices of application in conspicuous places. Kasi sasabihin mo, nasa barangay, nasa area applied or sa munisipyo, merong mga ganong conspicuous na visible. Okay. And then, yes, affidavit of undertaking also, yun yung sinabi ko na in case na may agreement, mag-undertake siya, yung landowner applicant, or that as to the list of tenants, bona fide occupants to be affected by the conversion. Okay, so within the area. Okay. And then payment of or shall pay disturbance compensation. Again, part yan sa undertaking. Okay. the billboard has been erected, okay? And not to undertake premature development kasi nga baka naman may conversion. So may perjure use effect yon. So pwede siyang i-charge later on kung not really telling us the truth. Kasi nga kung may premature, either i-deny yung application or we cannot give due course, or kung okay, nandiyan na yung premature, but because yung project is really viable, so kung i-approve, yet the bond is forfeited. Okay. So that's why there's sa part sa undertaking is actually the authority to forfeit the bond. So there's no need na i-show cause pa siya na may ano pala may premature kasi nga because of the undertaking nandun na. So actually ang laki talaga ang bigat nung ngayon because kung when you say na walang prematurity, and then at the same time, in the event na may prematurity, automatic forfeiture ang mangyari because of your undertaking. Okay. And then you undertake also na you have to disclose. This is actually a disclosure statement na there's no other case involved regarding the subject land holding. Okay. So in addition, yung mga certifications coming from important agencies of the government. So as I said, because of AO1 series of 2019 on the streamlining process, amending AO1 2002, ang Housing and Land Use Regulatory Board certification comes in only for those lands applied for land use conversion within highly urbanized and independent component cities, sa dalawa lang. So if you're not a highly urbanized but you are an independent component city, so you still need to submit the Housing and Land Use Conversion, Housing and Land Use Regulatory Board certification. But what if it's not it's just a component city? No, you do not need to submit an HLURB certification. You only need to submit the Sangguniang Panlalawigan certification. And at the same time, yung Sangguniang Bayan. So kung Sangguniang Bayan ka, there's no need to get a certification from the HLURB. Okay? Sa Sangguniang Panlalawigan ka. Kaya nga merong, I do not have my particular, meron kaming na-deny because nag-apply siya Sangguniang Bayan pero meron siya nakasubmit but walang Sangguniang Panlalawigan. So it means to say, hindi siguro in-approve or walang approval by Sangguniang Panlalawigan yung ginawa nilang ordinance. It's a must. Dapat may counter kasi part yan sa process ng reclassification under the local government code and pursuant to MC 54 of the Office of the President. In 1993, hinarmonize yung land use conversion plus the reclassification rules plus the DA rules and DILG, DAR, DILG, HLURB, and DA. So yung apat na yon under MC 54 and as implemented in MC 54 also, series of 1995. The Joint Memorandum Circular of DAR, DA, DILG, and HLURB. Okay? Kailangan you familiarize those. You can Google that. Okay. And then, DA certification, especially kasi under AO1, very, as stated in Section 7 and Section 8 of AO1 2019, dapat yung DA process certification is attached to the LGU certifications na reclassified siya. Kasi ang intent nun, dapat ang participation ng DA is on the right? Reclassification. So, amending yung prior na kailangan may DA separate. No. Dapat yung DA naka-attach with the LGU certifications. However, if the situation is such na pursuant to DAA 01 series of 2017, kasi kailangan sila may certification, and then wala, nag-reclassification pala after 2017 of DAA 01, then you need to submit the DA certification as part of the yung reclassification process. Okay? So that's how it is with regard to A01 2019 on DA certification, amending A01 2002. And then, as I said earlier, yung DNR certification on yung ECC, kasi may mag-submit ng DNR certification whether NIPAS ba siya or blah blah blah. So if there's a statement there that says na it is within ECA, so therefore there's a need for an ECC. But that ECC will come afterwards assuming ma-approve yung application. Okay. And then Department of Energy as regards kasi may mga energy virtual virtual one-stop shop system pursuant to that law, EVOS law. Now, pag mga solar projects, etc., priority sila. And then at the same time, may endorsement coming from the Department of Energy. Okay. So yung mga billboard, well, sa public notice requirement, merong ganong kailangan mo 4 feet by 8 feet kasi visible enough to the public. And then kung depending on the hectareage being applied, 1 billboard each kasi hindi naman pwedeng in 1 billboard lang. Kasi baka hindi dadaan doon, may kanto, hindi madaanan, hindi alam nila. And then later on, meron ng project, tsaka lang mag-protest, sasabihin ng mga protestors na protesting the conversion project na hindi namin alam. So mag-file sila ng revocation. Okay. And then it has to be written in local dialect. Kung Mindanao, Visayan, Cebuano, Visayan, Iliga, yes, Surigao nun, if it's in Surigao, in Butuan, the local dialect there has to be written. Okay. So that's an example of a public notice. Please note yung mga fill-upan doon dapat filled up. Okay. Except yung approval kasi later on pa. Okay. And then bond to guarantee against premature conversion kasi nga baka it's an attempt to evade coverage. So there has to be payment 2.5% of the zonal value, whether in cash or manager or cashier's check, or surety bond mas taas-taas kasi 15% of zonal value. Okay. Of course, may amendment during the time of Secretary De Los Reyes regarding yung private surety. But the problem with the private surety kasi it's 1 year so you need to renew it every year. Ang sa GSIS merong 1 year or dapat may provision na kung 5 years, 5 years. Okay. The same has to be posted upon filing of the application. It serves as a guarantee against premature conversion kasi nga kung may premature, automatic forfeiture. So alam na nila yon. So pwedeng sabihin nyo in advance na pag may premature, well, either yung bond nila posted will be forfeited, or that the application will be denied because of premature development kasi nakasabi din doon. But overall, you have to check kung ma-outweigh ba niya kung yung socio-economic benefit study. Okay? You have to look into that. So yung overall documentary document submitted, you have to evaluate. Okay? And then refundable or convertible into performance bond. Yes. Of course, forfeited in favor of the ARF, yun yung nakasabi sa law na in the event na forfeiture goes to the Treasury. The ARF, pero actually National Treasury man ang ang may jurisdiction on that. Okay. Ano yung mga exempted from premature conversion? Housing if it's a socialized housing project per certification coming from the HLURB, or it's a resettlement project courtesy of the National Housing Authority, or it is within the Community Mortgage Program project of the National Home Mortgage and Finance Corporation. Okay, so in those situations, at the same time na priority development area, one-stop shop applies. So wala siyang bond to be posted. However, pag once approved, they have to post a bond. Okay. Performance bond, so di na ito masyadong so parang 2.5% pa rin and 15% of the total zonal value kung GSIS applies. Okay. Patapos na ang conversion. Sige. Posted within 5 days, and it is supposed to ensure faithful compliance. Okay? That's why, kung hindi ma-comply, yung 5 years, goodbye. And then refundable upon completion of the project. So kung matapos, very important, I'd like to emphasize na kung matapos na yung 5 year or hindi mag-abot ng 5 years, tapos na yung project, apply for refund. But the refund, part ng is the recommendation of the Provincial Agrarian Reform Program Officer. So probably kayo yung mag-inspect kung natapos na ba yung project. So therefore, di ba may copy sa inyo na naiwan, you have to check on it kung tapos yung development project, and then ipa-recommend kay PARPO. So pag ma-receive dito ng LUCC, kung assuming more than 5 hectares, we will check the documents, and then kung may recommendation ng PARPO na tapos na yung project, so refund yung we will request from the National Treasury the refund of the same. I just do not know the number of days kung lalabas ka agad, kasi kukunin pa yun sa ARF, sa National Treasury, sa Bureau of Treasury, sorry. Okay. Again, although na-discuss ko na kanina, so the application shall be acted upon within a period of 30 working days. That's under Section 51 of 6657. Go check. The same din yan ginamit sa DARAB. DARAB rules, Section 51, also 30 working days. Okay? And then, pero meron siyang exceptions. Okay. Last. Kailan siya mag-toll yung 30-day running period, ma-interrupted. Okay? Ito lang. So watch out kung may mga matagal sa inyo dyan. Yung filing, kung mayroong protest sa application, that's the time na yung 30-day working period from the time nag-OSII and na-deliberate. Kung may protest, na humabol, all that, merong ongoing conduct public consultation kasi again, merong belatedly nag-protest, and then non-completion of the OSII. So yung 30-day hindi matapos because due to fortuitous event. Okay? Then there's a need for the conduct of a hearing for clarification on any of yung sa object. Bakit residential? Yung reclassification pala niya is commercial. So, kailangan i-check mo yan kasi dapat nag-jibe yung hindi sinabi doon. So, may misapprehension of facts. And then, other analogous circumstances related to 1 to 4. Okay? So, that ends my lecture on conversion.